About 10 years or so ago, maybe 8-ish, we began to recognize some of the unique problems with cases where children had been separated from their parents for extended periods of time. And so the remedies that were available, the resources that were available to these families were quite limited. So I'm going to briefly cover sort of the nuts and bolts of the Hague Convention, and just talk about the context in which this model that my colleague and I have been using. The Hague Convention on the Civil Aspects of the International Child, there's signatory countries who agree to cooperate for the specific purpose of returning abducted or wrongfully retained children to their habitual home country. That's sort of the essence of the Hague Convention. There's currently 97 signatory countries. The US became a signatory in 1983 and Canada in 1988. The latest was Armenia, and that's in March of 2018. The idea is that wrongfully abducted or retained children should be returned home promptly, and a parent should not be able to obtain custody by virtue of having engaged in improper conduct. That's the essence of the Hague Convention that's there. This basic provision means that a left behind parent in another country may seek the return of a child in US federal court or other central authority countries and file a petition, a Hague petition, to have that child returned. So a court decision under the convention does not determine the custody of the child in the other country. Doesn't determine whether the child is to be returned or by which country's court they will hear any custody dispute. So how do you establish a prima facie incoming case on Hague abductions? It's prior to the wrongful removal or retention, the child was habitually resident in a foreign country. The removal was in violation of that country's custody rights, and the petitioner was actually exercising custodial rights at the time of the wrongful removal or retention. There's certain defenses. So if you have a parent who's a taking parent, they may say the petitioner consented. They said I could go. They signed a paper. They signed a temporary consent. Or we got there and they acquiesced. They didn't protest. They didn't say anything about it. They maintained regular contact with the child via teleconference or Skype, and they didn't say anything about you need to bring the child back. Essentially, repeatedly acquiesced. Or the child has become well settled. What does that mean? Well, that's always a question. In the new country, that is one of the defenses that is often used, but it's difficult to prove without involving the child. Well, the Hague Convention and the remedies available for taking and left behind parents don't easily allow for the voice of the child to come in. There's also the grave risk. So grave risk is one of the defenses. This is more narrowly applied, but essentially it's that the child would be exposed to physical or psychological harm or an intolerable situation if they were to be returned. One of the other defenses is a human rights exception, that it would, quote, shock the conscience of the parent or the child. This is almost never used, but it's one of the defenses. And the other one is the child does not wish to be returned and is old enough, mature enough to have an input and a voice on this. So the work that myself and my colleague have been doing was to offer mediations for these cases. And the idea was to introduce some incentives. What are the incentives to mediating these types of cases rather than litigating a Hague case? Cases are very expensive to litigate. It's not only few lawyers who specialize in this. There is no right to counsel on these Hague petition cases. The legal aid and the pro bono representation is available, but it's difficult. So one of the other issues is the left behind parent may have been cut off from the child for an extended period of time. They may have had no access. And that urgent need to reestablish contact for that left behind parent is there. So they're often looking for, how can we quickly resolve this? And so often mediation offers an alternative to try to look at some of the issues and the aspects that are there. There are also some barriers to mediation. Sometimes there's immigration or criminal problems that will prevent settlement options, and so some of the ideas about how do you come up with reasonable settlement options if it's going to be a return case became more limited for both of these parents. So the idea of mediation to be able to open up those possibilities was there. Sometimes it's finances. Sometimes they cannot travel to a central location to be able to mediate. So one of the questions early on is, if we're mediating through a webcam, a web conference, a video screen, and other people are present, how does that impact the dynamics? Counsel for the left behind parent. There are challenges because sometimes the left behind parent they will help them identify and find an attorney to represent them. But often, that attorney has never met their client. They've talked to them. They may have had very little contact with that parent who's left behind. Sometimes there's language barriers and there's no easy access to translation. And so they're trying to represent a client with whom they have little to no relationship. Oftentimes, parents lack both communication skills or the knowledge regarding the children's developmental needs. They may be poorly or undereducated, may have very limited knowledge of child's age and stage kind of developments. So, and the child may be estranged simply because they've not had access to this parent for an extended period of time. And so the idea of the child returning to an unknown parent, through the eyes of the child, what an experience for the child that's there. So the project was called the Hague Convention Mediation Project. And it started with my colleague Doug Frankel. He's a lawyer and he's a law professor at the University of Pennsylvania. The idea was to provide free mediation services for these parents, and to also use more advanced law students to begin to train sort of the next generation of lawyers in how to know a bit more about these family law cases. As coming out of law school, you don't get a lot of family law training. You certainly don't get a lot of training in how to mediate Hague petition cases that are here. So, the idea that there needs to be another generation that kind of understands these concepts and figures out how do we help these families is something that was appealing to my colleague and I. So the inaugural mediation training conference was held at the University of Miami Law School, and this was in pro bono matters. And so initially it was all pro bono kind of services. In 2012, the project entered into a referral partnership with the U.S. Department of State Office of Children's Issues. The way it works is that the State Department will receive the incoming Hague Convention return request. This is from the left behind parent. They will confirm that both parents are interested in mediating their dispute. So one of the things that we look at is that, what are the advantages? We certainly try to promote the idea of mediation, to say, here are the advantages. So it's all voluntary participation by the parents. What's pointed out is that Hague litigation is going to make a determination of where the child's future and legal home will be. We can, as a part of a mediation, not only talk about where the child's future home and legal home will be, but what that access might be like if the taking parent is not going to return to the child's habitual country of residence, and to create an opportunity for the parents to be more empowered to make decisions about the child, because in many of these cases we're talking about, usually at the end of the Hague litigation, that's it. There's no services. There's nothing there at all for these parents. Well, these are some of the most high conflict parents. There's lots of anger, there's lots of animosity, there's lots of distrust. If you're one of the parents who has had the unfortunate experience of having your child taken from you, abducted, and to have limited resources in knowing how do you begin to build a bridge with the other parent who took your child. So in 2013, the parenting coordination, mental health parenting coordination aspect of this was introduced into the pilot project. The lawyer mediators prior to this time were mediating these agreements, but recognized that there was a need to add some child-focused elements into the discussion. So one of the reasons of bringing in the mental health parenting coordination component was not only service provision, certainly we wanted to add those elements to the model, we also wanted to be able to introduce the idea of aftercare. The idea was for these parents to be able to have access to parenting coordination services if they were successful in reaching a settlement agreement in these Hague matters. But there was no research on this model, and there's still no research on this model in terms of just being able to give you data, and having randomized trials for this. The idea then, in 2013, this model was expanded to include the mediation team that would be not only the lawyer mediator, but also the mental health parenting coordinator mediator, often law students that were involved in this as well. So why? We know that there's some long-lasting effects of abduction, not only on the left-behind parent, but also on the left-behind family, the extended family. And we know that there's an impact if the child is returned and if the child is not returned. So that's, as we look at these long-lasting effects of abduction, the idea of being able to offer a support service during the process of trying to resolve their dispute and post-settlement seemed like a no-brainer. Why wouldn't we offer these kind of services to these folks that were there? Part of what the pilot project does versus sort of what I'm calling traditional family mediation, I know there's different models, but there's certainly traditional neutral interventions and feedback that is provided. It's a confidential process, just like it is in more traditional domestic cases. But there's child development information that is provided, depending on the age and stage and how long the child may have been away from the parents. Some of the parent-child adjustment issues. Did they ever have a co-parenting relationship? They may have never had a co-parenting relationship at all. How am I going to build a co-parenting relationship? It was a sort of a one-night stand. And to introduce the idea of, would you be interested, parents, in an aftercare component? The label is a little less important than being able to direct parents to access to support services post-settlement dissolution. That's the idea. This is a quote from my colleague, Marilyn Freeman. She talked about in 57% of this, they reported very significant effects, and this is where the reunification occurred less than 1 year. There was 80%, between 5 and 1 years of after abduction, where they returned very significant effects. And then in the 12 interviews where reunification occurred between 6 and 10 years, there were 75% who reported significant effects. So one of the problems on trying to look at the data is that we don't have good data. We don't have good prevalence data. We don't have good incidence data. In trying in the early part of this project to collect data from the US State Department, they hadn't been collecting the data. So this is how the process is set up. The return request is received at the Department of State. The voluntary return letter is sent. So there's a letter sent to the taking parent. You took this child wrongfully, and you should return the child. And they usually ignore that letter. But the letter is sent nonetheless. And then the introduction from the country officer. There's a pro bono mediation program. If you would be interested in mediating this to resolve your disputes, both parents have to agree that they want to do that, and then it's referred to the project. The project has taken on assist the petitioner in obtaining and securing counsel, and will contact both the parties and counsel, and determines if the case is accepted or rejected. Usually the State Department is providing counsel for the left behind parent. The taking parent may or may not have counsel. If they want counsel, the project then will try to identify counsel for that taking parent to assist them. So in the intake and lawyer referred matters, these are non-central authority referred cases. Generally, it's the lawyer who has heard about the mediation project. It's on the State Department website, it's on the UPenn website, it's on several other websites, so sometimes folks have heard about it, and they'll contact the pilot project mediation team and then make a determination. Are we available to provide these services? And we go through the same kind of logistical accept or deny that we had. What style of mediation is used? It's similar to domestic cases in that we're trying to facilitate a discussion and a negotiated settlement between the parents. That's the idea of what we're trying to do. So this pre-mediation preparation, you're certainly looking at the Hague petition that's there. Where will the process be conducted? We've talked about some of the logistical challenges. Is it all in the same place? One or more people on video conference? How we provide the translation that's there? Who should be present? Up to this point in time, we have not included the children. Okay, so the children have not been brought in to the mediation process. It's something that we've talked about, we've discussed. Some of the logistics of doing that have been prohibited. Certainly with older children, we have been able to get the voice of the child represented, but not directly. So a typical case would be the taking parent, all counsel, and the mediation team is in a United States city because we're doing this for the State Department. The left behind parent with a translator is in Buenos Aires or some other place via video conference. This is the more typical case that we have. A mixed model is something also where the taking parent and the counsel or child's therapist is in Florida, the left behind parent is in New Zealand, the mediation team and counsel for the left behind parent all appear via video conference. More recently, we've done cases where everybody is on Zoom web conference. Everybody, whether we're caucusing, whether we're meeting together. One of the things that Zoom allows is you can go into private meeting. It's kind of like a virtual caucusing, or you can all come back into the same meeting room. You can also use a whiteboard to show, information that's there. So we've been able to use that successfully. But one of the questions, I'm a psychologist. One of the things that occurs to me, I don't have the answers for. I have more questions than answers. Is what's the impact of doing all of this virtually, doing all of this without sort of the live, interactive dynamics. But in these cases, there's just so much emotion that's there. There's so much that goes beyond just facilitating negotiation and possible resolutions that's there. There's a lot of the emotional components that are there. So we have heretofore not said we would not do mediation if we did not have access to the video. So we've not just done a mediation on the phone. We just felt like that would not be successful, that we at least needed to be able to see the parent to see us to see the attorney, and so trying to bring that in. But that's a typical. Will the team be meeting with the mental health professional of the child or the child's advocate? In several cases that we've done, the mental health provider for the child has served a critical role because they've provided input, and this is particularly true if they don't take sides. If they're there and they're serving as the child's advocate and they're just trying to educate each parent, the lawyers usually draft the settlement documents if a settlement is reached, and then making a determination of if there's no settlement, is there an interim agreement until the final court hearing? And then make a determination of will there be mirror orders in the other country? What's the enforcement capacity of that? Do parents want parenting coordination or support services if the child is to be returned. If the child is not to be returned, but there's an access case, who's going to facilitate that? Who's going to do the monitoring of that? And if so, then the mediation team or the project team tries to identify resources in that area where the child is going to reside, whether that's the habitual country of origin, if it's a return case, or if it's an access case, who's going to do that where the child is living now. So the settlement, there's some key elements of this. I mean, the parenting plan, we try to be as detailed as possible in the settlement arrangements. Where's the location of the access? Are there immigration, reentry barriers? Who's going to accompany? Who's paying? Where will the child be staying? Will the child be staying with the other parent? Hotel accommodations and so forth. Who's going to be monitoring? So one of the things that we don't have is we have no research on the efficacy of this model. We are wanting to get some data. We have anecdotal data, but we don't have any. And to the best of my knowledge, there's not another model that's like this in other countries. If you know of one, let me know. I've done a lot of work and I can't find one. But we want to know, does this help build a more effective and sustainable co-parenting relationship? We think it stands a chance, but we don't really have hard data. As a social scientist, I don't know that yet. But we wanted to start somewhere and at least offer the services that are there. And we don't have a decision tree for which cases are going to be appropriate for the model or not. We have ideas about that, but we don't have that. So we've had some good experiences. Since its inception in 2009, we've mediated 23 Hague matters, and 15 of those have reached resolution. Since the introduction of the mental health PC part of that, 85% have resulted in resolution. But we don't have really good post-settlement data. We're still collecting some of that. But I'm reminded, I referenced Marilyn Friedman, who said that we cannot continue to think we've done enough to protect children from the harmful effects of abduction simply by returning abducted children to where they lived before. And those who are returned often cannot pick up where they left off and struggle to deal with their lives after abduction for a long time. So we owe something better than that. So thank you very much.